mischievous mischief or even arson or something like that.
Okay.
If he's arrested and he waives his preliminary hearing, can he be brought to trial without the grand jury indicting him? Without going through the formality of a grand jury indictment?
That's a great question, Richard.
Yeah.
Let me just kind of let's talk criminal law, basic criminal law 101. Whenever someone is arrested for a felony charge, what they have to do within 72 hours of being incarcerated, they have to do what's their initial appearance. And several things happen at the initial appearance. One is you have to be formally told what your charges are, so you know what you're facing. Okay, that's number one. Number two is you have a bond, whether you're entitled to a bond or what the amount of the bond, so a bond setting. And the third thing is a preliminary hearing. Everybody that's in charge with a felony has the right to request or demand, it's your right, a preliminary hearing, and that's a very low-level hearing that the state or whoever, the prosecuting agency, has to put on proof to a judge, probable cause that a crime was committed, probable cause you were, the perpetrator of the crime. So that's kind of the threshold. Now you can waive that right, okay? As a criminal, you can say, that's one of the things the judge will ask you. Do you want to waive that right or no? You're supposed to also sign a form if you waive that right. So once that's done, and then once you post bond, then you of course out on bond, you're on your own recognizance with a bondsman. And the case then is supposedly then sent to the grand jury, okay? The DA is supposed to then takes jurisdiction of it and it goes to the grand jury. So short answer is the grand jury then has to kind of also pass on it as well. So also it's got to go to review to a grand jury.
I gotcha.
Yes.
And I'll tell you on that preliminary side, just from the media side, my old reporter days, that's where like WLOX and